Good afternoon, everybody, and thank you for joining us today on this webinar. Jacqueline and I are joint heads of the family team at 5 St Andrews Hill. Jacqueline was called to the bar in South Africa in 1986 and is the equivalent of our Silk in South Africa. I was called to the bar in 1995, and as I say, we're joint heads of the family team. There are 14 of us in the family team, and with the exception of some of our most juniors, we all moved together from a former mixed practice set on Bedford Road to 5 St Andrews Hill in 2015, where we've all practiced family law ever since. So we're a close-knit group.
And we are pleased and proud to be joined by lawyers from South Africa. South Africa, as you may know, was subjected to some of the most stringent lockdown restrictions, and they are starting to roll out remote courts. We welcome among our South African attendees the Honourable Ms. Justice Moodley, a High Court judge, Zenobia du Toit of the law firm Miller du Toit Klute, one of the coordinators of the annual Cape Town Family Law Conference, of which 5 St Andrews Hill is a proud sponsor, Barry Skinner SC, Chairman of the KwaZulu-Natal Bar Council, Susan Abro, past Chair of the Family Law Committee of the Law Society of South Africa, and Pat Moodley of the Department of Justice and Constitutional Development, and 2 of her colleagues. Welcome those who attend from afar and welcome those who attend from closer by. Next slide, please. The introduction of the remote access family court as a result of COVID-19 coronavirus restrictions. Like the rest of the UK, our practices changed on the 16th of March 2020 when the Prime Minister introduced social distancing measures to keep the public safe from the COVID-19 pandemic. The President of the Family Court, Mr. Justice MacDonald, issued guidance for the Family Court just 3 days later, on Thursday the 19th of March, in his first version of the Remote Access Family Court COVID-19 Coronavirus, which informed us that with immediate effect, the family justice system was moving to operating remotely, unless there were exceptional fact-specific factors in the case that required personal attendance at a hearing in a court building. This, of course, changed again just a few days later on Monday, the 23rd of March 2020, when the UK went into lockdown and the family court system operated remotely without exception. Since the release of version 1, the President has released 5 versions of his guide, with the last published on the 26th of June 2020. From the first to the last version of the guide, the family court has operated exclusively remotely. Since then, some of us have had physical hearings, but only on the rare occasion. We have all worked in the remote family court throughout lockdown, and now that the restrictions have been lifted, we continue to practice in the remote family court. What we want to do in this webinar is share some of our experiences throughout lockdown and since the lockdown rules have been lifted. We intend to share with you what has been a success and what a failure, with the hope of imparting some tips and tricks for those also working in the remote family court. Finally, we will explore what our views are on the future and then answer any questions you may have. Tess, if we may have the next slide, please.
Thank you. Access to the remote family court by video and telephone. Once the court opened up remotely during lockdown, the only 2 methods of the court conducting the hearings by telephone or else by video. At the start of lockdown and the courts operating remotely, we experienced considerable variation between regions in the country, as well as between courts and even between courtrooms in certain courts on the mode and the platform used to hold a remote hearing. This is likely to have been down to personal preference of the judge in the case, as well as availability of the technology in the court or on the judicial computers, which we quickly had to adapt to. So we had to adapt to using multiple platforms. We have between us as a team undertaken hearings by BTMeet, BT Meet and Greet, Powwow Now, Skype, and Zoom, and now CVP. In my experience, the most common type of hearing, certainly in the earlier part of lockdown, was by telephone, which was for the most part effective, but with the introductions of more hearings being conducted by video, our experience is that video hearings are more effective. Initial video hearings were done by Zoom or else by Skype for Business or other platforms that were similar to Zoom. The Ministry of Justice was slowly implementing plans for the court to move to a centralised remote access system it called the Cloud Video Platform, or CVP for short, long before the pandemic and the family courts operating remotely. HMCTS released CVP on an urgent basis to provide a preferred video hearing platform when physical courtrooms were closed or restricted. CVP is now the preferred online video platform used in all hearings. It is secure and it is GDPR compliant. Be warned, however, as we have experienced since lockdown and CVP being rolled out, there are slight variations in the way that it's operated between courts, which we'll share with you later. Thank you. Next slide, please, Tess.
So, initial concerns about the remote access family court. In the 2-week period between the 23rd of March and the 6th of April, audio hearings across all courts and tribunals in England and Wales increased by an astonishing 500%, and video hearings by 340%. When we first started practicing in the remote access family court, there were many and significant hiccups that we each encountered, which led to concerns about how effective this new justice system would be. We all talked about the need for the lockdown restrictions to lift as soon as possible so that physical attendance at court could once again take place and we could get back to the way things were. The concerns we held and experienced in the early days when the family court opened remotely included the number of cases that were adjourned, sometimes the night before the hearing or on the day, and sometimes even after the hearing was due to commence. The number of hearings where the court made only interim or temporary orders rather than final orders. This led to an increasing backlog of final hearings. Concerns about the ability of clients to participate in the hearings that did take place due to a lack of technology led to fears about fairness. The move over from paper bundles to electronic or e-bundles and getting to grips with the change was often slow and cumbersome. E-bundles were not served until the last minute, and if they were served, they did not contain all the documents. There was a lack of consistency across the courts about who was responsible for accepting and managing the e-bundles. Getting to grips with using e-bundles included the difficulty in reading the bundle on a dual screen setup while using a video link and also taking notes. In respect of our clients, we held concerns for clients at home in cases involving domestic abuse or our clients with disabilities or cognitive impairments. Equally, we worried about those clients or witnesses who required the use of an interpreter and how to hold a remote hearing with the use of an interpreter. Telephone hearings are more accessible for clients. However, the downside of conducting a telephone hearing is that you cannot see everybody, and therefore it's not possible to read body language or observe facial cues. We've been so used as lawyers to reading the room, as it were, that hearings over the telephone led to concerns that justice would not be dispensed. A further fear was how we would be able to obtain instructions or give advice during the hearings. And lastly, perhaps surprisingly, our experience with the remote hearings are exhausting. Next slide, please, Tess. Best practice and practical tips. We've set out our experience in the early days. What have we learned now, and have things improved since the early days? Next slide, please, Tess. General guidance for how to behave or conduct a remote hearing. The important thing to remember is remote hearings remain court hearings. The solemnity of the occasion should be observed as closely as if the hearing were in a courtroom. Advocates should dress as if attending court, although not required to robe. The background and lighting should be appropriate. Participants must ensure they will not be interrupted. Participants should not move away from the screen without permission. The usual restrictions on eating and drinking, or not eating and drinking, in a courtroom apply. All reasonable steps must be taken to preserve the confidentiality of the proceedings. The judiciary and other advocates should be addressed as if they were in a physical courtroom. It's not necessary to stand. Anybody attending the remote hearing should ensure they have a good connection. All participants should join the remote hearing prior to the judge. The judge's camera and microphone should remain on at all times. Participants should have their microphones muted unless addressing the judge. And mute your microphone should be the takeaway from this webinar. Participants should leave their cameras turned on at all times. The court will identify at the start of the hearing the participants. The court will then give warnings to all parties regarding not recording the hearing, as that is done by the court system, and about confidentiality. When the witness is giving evidence, the witness must keep a camera and microphone on. And time should be provided for advocates to take instructions during the hearing. Next slide, please, Tess.
Thank you. So that was the general sort of setup, but dealing specifically with telephone remote hearings, so long as everyone in the case has access to data or and has a good signal or Wi-Fi, telephone hearings are, in our experience, simple and reliable. Telephone hearings allow the use of mobile phones and they've therefore made access to justice really simple, so long as you don't drop out of a call. However, the lack of visual cues can make these hearings difficult, certainly difficult if there's anything more than submissions in a case, due to the fact that you do not know whether parties or the judge is engaged and listening. In other cases, hostile interactions are difficult to manage. What we've learnt and what we wish to impart so far as practical tips for telephone hearings include that you should send an email to the court confirming everybody in the case's telephone number at least 3 days before the hearing and then 24 hours before the hearing. Don't expect the court to respond. It varies between different courts. Some will respond in thank you and some won't. But so take it as read that the court has received your email if you send one. You should make sure that your client is aware that they must take the call in an area where they're on their own and they will not be disturbed or overheard. Also ensure that they are aware that they must not record or transmit the call in any way. Test their number and telephone line at least an hour before the hearing. Make sure they can hear you and that whilst talking to you, they have access to the papers in the case or an e-bundle. Ensure that you agree a method of how you will communicate with them during the hearing. I tend to take my telephone hearings on my computer and then I have my iPhone in front of me and I either WhatsApp or text my client or else email them and it pops up on my screen. But if you do something similar, that means you can take instructions during the course of the hearing. Ask your client to press *6 when they're invited into the meeting. That will mute them. And if they then press *6 again to unmute themselves, should they have a need to speak, which is rare. If either of you get cut off, let your client know or else ask them to inform you so that the call can be alerted and reconnected to the call. Having said that, it's my experience that in BTMeet, it will note, the robotic voice will notify the participants that somebody's left the call. And what tends to happen is that the call ends the hearing and then recall everybody. But just in case, it's best practice that the judges and those legal representatives in the hearing keep checking with the parties that they're still there and that they also understand the hearing, particularly if the hearing goes on for a long time. Talking about long time, as Jackie alluded to, it's our experience that these hearings are tiring, which is surprising. It's my experience that between 45 minutes up to an hour is all that you should really schedule these hearings for before needing a break, unless the case is about to finish. Anything longer than 60 minutes, particularly going to be much longer, you should ask for a comfort break. or just a break in itself to stop exhaustion. So that's telephone hearings. Next slide, please, Tess. Turning now to video and in particular the CVP type hearings. These are very successful if you can overcome technical and connectivity issues. These hearings are more like being in a physical courtroom, certainly more so than using a telephone. You can see everybody's face and you can communicate with the judge and all the others in the case more effectively. You will need a second screen to read your documents, or else if you have one screen and you divide it in two, so you've got a split screen. Our tips for conducting videos, CVP hearings, you'll receive an email from the court specifically from the Microsoft team that will contain an invitation to join a CVP hearing. I've done a number of these hearings, and in the past I've received the email between 7 days and 3 days out from a hearing. And I had an experience recently in the CFC where they sent the email on the day, just 10 minutes before the hearing, which was heart-stopping because I just assumed we were having the hearing by telephone. I now learned that the CFC sends out the emails on the day. So that would be my tip. Dress as though you're going to be in video, but on a video hearing, even if you think you're not. The email that you receive will be from the Microsoft team. It will contain a link exactly the same as it would if it was asking you to attend a Zoom meeting. We'll have a meeting code which will start with HMCTS followed by a series of numbers. I've had a number of hearings where some contain a link and no pin, some have a link and a pin, and it really is dependent on which court. So but either way, you'll need to press the link to enter the hearing. And if there is a pin, you'll need to enter the hearing. When you receive the email invitation, you add the hearing to your calendar. Of course, that doesn't apply if it's minutes before the hearing, but if you receive it sometime before, add it to your calendar, and then the email link to the hearing will be copied into your calendar, which makes it easier to find the hearing when it's about to start. For optimum participation at the video hearings or else hybrid hearings, we would advise using a laptop, MacBook or desktop computer or the like. This is to enable you to use the presenter features of CVP. You can join a CVP hearing using any device such as an iPad, iPhone or tablet, but if you do not join using laptop, desktop computer, you will not be able to use some of the functions. Some of the functions will be disabled, which you'll need if you're an advocate in the case. You will need to use Google Chrome, or Google Chrome is the most effective or unproblematic means of joining a CVP hearing. So we advise you to download Google Chrome or else Firefox on your computer. Make sure it's your default browser, because otherwise you'll open up in another one and it won't take you to your CVP link. If you do, so download it, make sure it's your default browser. Otherwise, you'll have to cut and paste in your other browser. One tip, close down all other browsers on your device and all other links, all other apps rather, in the background, so that there's no competition for use of your mic or camera. I've once had a hearing and I didn't realize that Zoom was running in the background, and that was and I couldn't use my mic, couldn't understand why. So that would be our tip, close down everything. Once you press the link, you'll be asked to enter your name as you wish it to appear to the parties in the case, and then you simply press connect. If you've ever used Zoom or the like, well, you are on Zoom, so what am I saying? You'll be familiar that ordinarily you can see the other participants. If you, once you enter CVP, you'll see the list of all the participants who are attending the hearing, which will include a court clerk, and there'll also be a Microsoft participant, which is just the recording. You'll be placed in a waiting room before the hearing once you press the link, and once you enter, you'll see all the other participants. You'll be in a waiting room and you'll see the image of the Ministry of Justice building, which should appear on your screen. And then what usually happens is you'll see the court clerk, who'll then bring in the judge. All of your control icons are on the bottom of the screen. On the very left, you'll see a blue arrow pointing left. If you press that, you can hide the participant list, which does tend to take up most of the screen, and you'll also hide the chat room so that the visuals of the parties on the screen becomes much bigger. To turn on the mic or to mute, you just click the mic button, exactly the same as Zoom. I share with you one benefit of of remote hearings and the ability for the parties to mute themselves, or else the judge to mute the participants, and that is there was a hearing where one party, who was represented by very senior counsel, joined the CVP using a video link from counsel's chambers, and she started shouting during the hearing. And then everybody in the hearing could see her very animated but no noise, and it transpired that the judge had just muted her. So it's one really good way of dealing with hostile witnesses or else hostile parties. If you've got an e-bundle, which you will need in most hearings, and you manage that using Adobe Pro or other similar management software, make sure you've got that app open alongside your CVP app when you're in the hearing. If it's open, you'll be able to show your bundle by using the application window function. If it's alongside the bottom and it's reduced, you won't be able to share your documents. Once you've shared your bundle, all those participating will be able to see the page of the bundle you're referring to. So ensure that you haven't marked up your pages and you've got any notes on them. Once you want to stop sharing, you simply press stop share. Whilst on the video, it is not as easy to take instructions from your client as a telephone hearing for obvious reasons, because you can be seen and on a telephone hearing you can't be seen texting or emailing your client. In those circumstances, you could do one of two things, and this is what we've tended to do amongst our team. You can either ask the court for a break so that you can contact your client in private, or else, I know Jackie certainly has told me or shared with me her experience of what she just did, was she asked the judge if she could mute her microphone together with her client, and then she called her client. I prefer to ask for breaks so that the court can't see me as animated on the video, but there we go. Generally, video hearings are not as tiring as telephone hearings, but nonetheless, they can be really tiring. Because there's a need to listen really carefully, and they can be really draining as well. So do ask for breaks and do check in with your client, make sure they need breaks from time to time. And those are our tips. Thank you. Next slide, please, Tess.
How remote family hearings have moved on, and the future of the remote access family court, and the introduction of hybrid hearings. We've moved on since the government lockdown restrictions have been lifted, mainly with the introduction of hybrid hearings. Very few of us are having full physical hearings, which is in part due to the tighter recent rules limiting the number of persons able to meet at 6, which in a courtroom setting would include the judge and the clerk, leaving just 4 people who can assemble in a courtroom under permitted rules. A hybrid hearing is a hearing involving some in-person attendance in a courtroom, while other advocate participants are joined in the hearing using CVP. Now, a very simple concept, part remote, part attended, but such hearings require careful planning to ensure that the technology is set up without one device interfering with another and thereby rendering the hearing inoperable. Practical tips. The CVP, Cloud Video Platform, is capable of being connected to the JVS, or Justice Video System. Pre-COVID-19, the JVS was a system that had been used to receive evidence of expert witnesses remotely, or witnesses in prison via video link. CVP and JVS can be used together, but care must be taken before the hearing to adjust the location of the JVS screens, camera and microphones so that lawyers can participate in the hearing remotely alongside those that are physically in the court with the judge and any witnesses that are attending personally. CVP linked to JVS is a good solution for hybrid hearings where some participants in the court are in the courtroom and some are attending remotely, but only if the view of the witness and the judge is good enough to ensure that there's no disadvantage to those attending remotely, and the audio feed into CVP is good enough to ensure no disadvantage to those attending remotely. The main advantage of CBP connected to JVS is if set up correctly, it avoids the issues with audio feedback that can occur when hybrid hearings take place using only CBP. However, the significant disadvantage of hybrid hearings conducted by CBP with JVS is those attending remotely will only see on their screen what the JVS camera is pointing towards. If the JVS camera is set up properly, most of the courtroom can be seen. Of course, that takes pre-planning before the hearing starts. CBP can be used to conduct hybrid hearings without the use of JVS. And if you use another platform or camera and microphone, you can adjust the device to have a greater view of the court. Whatever setup is agreed for the use in the hybrid hearing, make sure that you leave sufficient time ahead of the start of the hearing to test your setup. It's essential that the technological setup for any hybrid hearing is tested prior to the start of each hearing day, and again prior to the commencement of the evidence of each witness, to ensure that the witnesses themselves know what to expect. Test the following. Is the camera in a location where you can see the witness in the witness box? Can you zoom in sufficiently closely so that the face of the witness can be seen? Test the microphones in the court so that the witness, judge, and advocates in the courtroom can all be heard by those attending remotely. Test for feedback on the sound. If two or more microphones are being used in the courtroom close together, there will be feedback through the platform that will render the hybrid hearing unworkable. Therefore, it's necessary for all those in the courtroom to wear a headset or earphones. All those present in court and on the remote platform should have their microphones muted unless they are speaking. Only the witness and the advocate asking questions active. I did say earlier, the takeaway from this should be mute your microphone. Otherwise, you might have, as was overheard in one hearing, you can have as many sweets as you want, but don't come into this room again. The judge should activate his or her microphone when intervention is required, but it should otherwise remain muted. There's likely to be a short delay between the speech in court and the audio feed being heard on the platform, so just pause as you're speaking to allow for that delay. All those participating in the hearing will require a laptop that is logged into the remote platform so that their faces can be seen by all who are not in court. There must be a laptop in the witness box that is logged into the remote platform so that the witness can be seen clearly by those not present in the court. The advantage of this is that the presence of a laptop for the witness removes the need for printed bundles in the witness box, as every advocate can and should use the presenter or share screen functions to serve pages from the bundle to the witnesses. If the judge wishes to refer the witness to any pages of the bundle but is unable to use screen sharing, or the judge has used a printed bundle, the judge can ask one of the advocates to bring the page up on the screen. Just a practical tip, when you're at court using the CBP, join it by the government or other Wi-Fi network. If you use the PCU, the Public Court Users Network, there will be connectivity difficulties. Tess, could we have the next slide, please? Advantages and disadvantages of remote hearings. A reminder of olden days. Do you remember trains and take-out coffees? I should have added a picture of a wheelie bag to carry your multiple files plus the laptop. An apparent disadvantage of the remote hearing is not being able to meet the client personally, but having to do so by telephone or video link. However, that disadvantage is more apparent than real. If you will recall the days of actual hearings, so often one would arrive at court to find the few conference rooms already occupied or reserved for use by Kafkas, the corridors crowded and not even a seat to be had. It is distressing for a client to have to discuss intimate and personal matters where the result of the court hearing could be life-changing while standing in a corridor with others in earshot. This is especially problematic where the other party and legal representative may be hovering but a few feet away. Add to this the logistical problem for the advocate of trying to open a hard copy bundle or view an electronic bundle on the laptop while on the hoof being jostled by passers-by. And let us not even mention the challenges in taking a note in these circumstances. By contrast, meeting, in air quotes, the client virtually before the hearing assures privacy and comfort. Often a vulnerable client feels more comfortable within the familiar environment of a home, or perhaps an office space. Domestic abuse victims are protected from a chance encounter with the abuser in the court setting. Remember all those cues to get through security into the courtroom, and how likely it was that the abused would meet the abuser in the queue? Taking instructions presents no more difficulty than turning your back in the actual courtroom if proper planning for this has taken place in advance of the hearing. Muted, as Maria has said, muted microphones while a telephone call is made allow for taking instructions or ask the court for a break. The advantage of a muted microphone on a CVP hearing while you make a telephone call is, unlike the actual courtroom, there's no risk of anyone overhearing what you and your client discuss. For the advocate, an overwhelming advantage of the remote court hearing is the ability to properly set up for the hearing in advance. Paper bundles, if used, can be placed appropriately. Laptops booted up, the required applications open, e-bundles downloaded and ready to read, notebooks and pen in place. Compare this with walking into a courtroom carrying 3 lever arch files, a laptop, a notebook, a coat, an umbrella, and trying to set up for a hearing in the minute available between the usher calling the parties into court and the judge entering the courtroom. Conducting the hearing from an adequately sized desk rather than crammed onto a courtroom bench. There's no elbow room when the bench is occupied by multiple advocates. Or worse still, perched on a press bench when there's no space available in the front row. All of this conducting the hearing from an adequately sized desk allows the advocate to concentrate on the case without distractions. Hearings tend to be more focused, with less time wasting before. How many of us have not spent an entire day at court, but only an hour or so of that in the courtroom? Endless discussions, sitting around waiting to go into court while another case listed at the same time carries on interminably, were part and parcel of everyday practice. Now, pre-hearing discussions by telephone or Zoom are to the point. Agreement or an agreement to disagree can be swiftly reached, and the case can commence and be effective at the appointed time. Another advantage, the creature comforts of readily available refreshments, lacking in most courtrooms, and clean bathroom facilities are not to be taken for granted. Add to that the savings in time and the cost of travel to and from court, and the case for remote hearings continue as the modus operandi becomes more compelling. Lest we forget, in times of actual court appearance, hearings did not always start on time because of delayed or cancelled trains and traffic jams. The delays caused by technological issues sometimes experienced in remote hearings pale into insignificance against the delays we encountered in the days of actual court hearings. Thank you. Next slide, Tess.
Thank you. So lastly, we consider, are these changes permanent, and do we need to all embrace the remote access family court? It is our joint view that the family court will continue to operate remotely in the future, and that the changes we have seen will not be reversed. Our lament at the start of lockdown of we can't wait to get back to the way things are seem so long ago now. We don't think we are going to ever go back to the way we were. It is our view that we have to embrace the changes and get used to the fact we are not going back. We will continue to work remotely, where a judge will ordinarily work in a court building, and we will continue to connect to the courtroom by telephone, BTMeet and its future incarnations, or else by video, CVP and any future incarnations, except when attending a court in person to directly question a witness in a hybrid hearing. We feel that full face-to-face public court hearings are likely to be reserved for committals and the most serious care cases, or those in the court of protection. And even then, it's likely, with more hybrid hearings and us becoming more accustomed to hybrid hearings, that even then hybrid hearings will be the norm. We will continue to meet our clients in a virtual space over Zoom or telephone, and we will continue our practices this way. It may well be the case that we could arrange to meet a client face-to-face in the same business space for final hearings, so that we can attend a hybrid hearing with a judge sat in court and us in a different space. But otherwise, we think these changes are here, and we welcome them. So thank you very much for joining us. We've actually managed to rattle through that quite quickly. We are open to answering any questions now. We've all worked throughout this period of the remote family court since lockdown. Save for the first couple of weeks, we've been really busy. And I think Jackie and I, when doing this and setting up, shared our experiences, we both are so much more busier post-lockdown restrictions being lifted, mainly because we can do 2 hearings in one day, or a conference and a hearing, which we simply couldn't do before. So we have a wealth of experience between us of working remotely, and we hope we've given you the most on-point tips. Do we have any questions from anybody? Let's have a look.
Hello both. Thank you very much for that. So I've got 2 questions that have come in.
Right.
The first one is, I have a case coming up to be conducted remotely by CVP where the client needs an interpreter. How can we manage that?
The courts are managing that very effectively. I had a hearing, multiple hand and many advocates, where one of the parties was sitting in Bangladesh and she spoke no English and needed the assistance of a court interpreter. The court provided an interpreter for her, and the party and the interpreter joined the hearing by CVP, so we could see both the party in Bangladesh, we could see the interpreter, but the interpreter used WhatsApp to be on the telephone to the party in Bangladesh, and he interpreted by WhatsApp throughout the hearing. It was seamless. It was far less intrusive than in an actual court hearing where you've got the translation going on in the background, because of course his microphone was muted, so we didn't hear the translation. Only the party in Bangladesh did. And that took place over 3 days of the final hearing, and without a problem.
The other question I have, which is, I have not yet had an effective FDR. With all of my FDRs being adjourned, have you had any of them, and how does the court manage them?
I can take this one. Yeah, I think that's a really common problem throughout lockdown. We've seen FDRs and other final hearings being adjourned, but I have had some FDRs initially during lockdown between myself and my solicitors and the clients in cases where it had been adjourned off. What we then looked at was alternative forms of dispute resolution. So we looked at mediation, roundtable meetings with solicitors and the clients. Was really effective. It was effective because people didn't know when they were going to get before a court, so they tended to concentrate minds. But I suppose answering the question specifically, I have had FDRs more recently. I've had one by CVP, and what took place then was that the judge was on the video. He heard submissions, he gave an indication, and then he asked whether we needed time and said that he would keep the camera rolling and he would exit the courtroom and indicated to us, let's say, for instance, it was 11:15, and said, I'll come back in half an hour, ladies, and see how you're getting on. And that worked really well. In another case, I've had another FDR, which was by telephone. So both parties made submissions by telephone. And that was quite draining. But what happened in that case, we got to the judge giving an indication, and he then said, I'll call you back into the hearing. So he let everybody exit the telephone, hang up, and then called us back. So it is entirely possible. either by video or telephone. The courts are operating them. Listening, I imagine there's a huge backlog, but of the backlog, I think if a case is waiting to be heard and doesn't know when it's going to be heard, look at ADR. Or I've also had cases where we've looked at private FDRs. But if you do have a court hearing, they are perfectly possible remotely and work really well.
I have got 2 other questions that have come in as well, which we can probably deal with quite swiftly. One from Robin. Do you have any experience of using Caseline as the digital bundle provision, and any tips for its use?
Caseline, no, I don't actually.
No.
Nor do I.
No, I've used, I first used a PDF software manager, and I've since used Adobe Acrobat. Let me have a look. Adobe Acrobat, and I've stuck with that mainly because I think my solicitors have used it. So I have to tell you, I don't know.
Okay. Well, there's another question from Gail. Is there a need to download an app for CVP like we do for Zoom?
No, there isn't, but it is advisable, as we said, to either use Chrome as your browser or Firefox, because what you'll find is if you say use Google or use Safari, when you press the link, it won't, you'll think what's happened, there's nothing happening. You'll need either Chrome or Firefox in order to bring up the actual virtual court, the HMCTS website, which will then allow you to enter the virtual courtroom. But no, you don't need to download an app. But I would say my experience was I left it about 10 minutes before the hearing, and it was the first time I had a CVP, and then realized I had to download Chrome, and it was that sort of, oh my God, panic moment. So download it beforehand. Make sure it's your default browser as well, because otherwise when you press the link, it won't take you to Chrome or Firefox.
There's some chat on here, and one of them from Pat Moody to all panelists is, how do we ensure security on the platforms that we use?
Well, we're told with no reason to consider otherwise that CVP is GDPR compliant, and that was one of the concerns at the start of lockdown and the courts operating remotely was, how do we ensure that these are safe? There was lots of talk about Zoom, which was being used, not being, as it were, safe and GDPR compliant. And there was some case law on that. But I think the courts took the view, we have to administer justice. The courts need to remain open. But in the background, they were furiously working, and that's where they brought out CVP, which is GDPR compliant. We don't need to ensure that they're confidential. If you are joining a court via either telephone, BTMeet, which has been set up by the court, or CVP, it will be confidential, GDPR compliant.
Well,
so can I just interrupt? I think that question may have come from Pat Moody, who is from the Department of Justice and Social Development in South Africa, and I know they're trying to roll out the remote family courts. So there is the McKinley, who are dealing with Her Majesty's Court Service, and Pat, I'd be happy to give you their details afterwards, so that you, if you need to liaise at that level where you're actually rolling out the court service, they would be able to assist you, because it has been one of the concerns to make sure that the CVP platform is secure.
Yeah.
Well, thank you very much, Maria and Jacqueline, and thank you everyone for watching and listening. I think we should probably end it there. And if there are any further questions after this, I'll send out a further email with my contact details, and I can pass them on to the panelists.
Thank you all for joining us. This is one of the lovely remote.
If I may say, in previous times, we would have invited you for refreshments after the webinar. We can't do that, so apologies that we can't meet you informally after this webinar.